Any mentioning?
Yes, may I permit to mention one matter for listing, my lord. One application was filed for abatement of this. It is fixed on 28.
28.
28.
28. You want to fix it earlier?
Yeah, board is fixed for hearing.
Let it come in a list.
Okay.
May I have my lords kindly to mention PLA number 61 of 2017.
Today's list?
No, my lord, it's not in today. I'm
For
mentioning
inclusion.
for inclusion. My lord had appointed me as the administrator of the estate for division of two components of the estate. With respect to one, there is no problem. With respect to the other, there are problems that have arisen, and it is not within my power to decide the manner of distribution.
Have you served notice?
I have. Yesterday there was a meeting called. Had intimated in the meeting that I'd be mentioning tomorrow today, and I was seeking my lords kindly for it to appear as to be mentioned any day, subject to my lord's convenience. If my lord so directs, I shall intimate that to the parties as well. Extremely obliged.
May I have my lord's kind leave to mention item number 30 of my lord's list. My lord, I'm mentioning upon notice. Today was fixed for commencement of cross-examination of the plaintiff's witness, my lord. I'm
Yes.
appearing for the defendant numbers 1, 2, and 3. My lord, we are awaiting some further material instructions from the client, without which we cannot commence cross-examination. My lord, I'm seeking an adjournment, my lord.
My suit, my lord. That matter she is mentioning. Like, can't stand in the way, my lord. But any day, my lord, prior to the vacation, my lord. My witness was in the box, my lord.
এটা একদম লিখে নিন on prayer of the learned counsel for the defendant. Witness action is adjourned to 19th May.
I'm deeply obliged, my lord.
Your Lordship, I pray for your kind leave to mention this matter for inclusion, Your Lordship. I'm mentioning upon note.
For your side, item number 1.
My lord, I appear on behalf of the intervener, my lord. I am led by Mr. Probal Mukherjee, my lord. My lord, I'm praying for some time, my lord. My lord, in a coordinate
Any
bench-
affidavit is to be filed?
I think they have filed one of the intervention application. We have also filed our objection to it. Affidavits are complete, but they are not. They were supposed to move the intervention application, but every
lord,
time, my lord, they are seeking
before a
for time. I
coordinate-
do not know.
My lord, before a coordinate bench, my lord, the matters with relating to the power of attorney is pending, my lord. It is at the verge of
But
hearing, my lord.
may I say this? But there is also a 34 of the state, and at this stage, they have no right to intervene. At the execution stage, once the 34 is disposed of, then when the matter comes for execution.
Let me hear the matter. Last chance.
Yes, grateful, lordship.
Every time you can't take adjournment. Every time you will come and say,
just
please give
wait.
adjournment. That is not
No,
proper.
my lord.
Order sheet ta dao na.
Before the coordinate bench, my lord, it is pending. That's why, my lord, it will make much more easier for your lordship if that is adjudicated, my lord.
He was partly heard.
Well, they are, you see, well, they are not parties to this proceeding. Well, it is the award is in the name of Punalur Paper Mills Limited. There is an agreement in respect of Punalur Paper Mills Limited.
On prayer of the intervener, the hearing is adjourned to 30th April. No further adjournment will be allowed to the intervener.
All right.
Grateful.
I will hear the matter and dispose it of.
If your lordship fixes the time, my lord, Mr. Probal Mukherjee is there, my lord, in this matter. If your lordship fixes any time, my lord.
It will come in the list on the first. This much I will say.
Great, lordship.
Item number 2, 3.
If you want to fix a particular time, then tell me I am releasing this matter.
No, my lord. I am not.
Everyone is equal to me before this court.
I completely understand, my lord. I'm not.
Item number 2, 3, and 4.
But this is the
We appear for the plaintiff.
application which my lord was hearing. On the last day I made my submissions, they have completed their submissions. I had commenced my submissions on the last occasion. It fell from
Reply.
But it fell from my lord that I should bring a written notes of arguments.
I was hearing J3.
J4.
J4, that's the demander application.
No, J4 is my application order. Yes.
Order 13A application for summary relief. There are two applications taken out by them. One is a judgment upon admission. They said they would not really pursue the judgment upon admission and laid more stress on the Order 13A application. Order 13A, the plaintiff has made his submissions. I was making my submissions. But on the last occasion, it fell from.
Let me refresh my memory.
Yes. We had filed a notes and arguments.
My lord just does that. My lord wanted me to come with a list of notes of argument. Well, my notes of argument is ready. Because of some hitch in the office, my lord, printouts couldn't be made ready. If my lord would hear me I am prepared without the notes of arguments also, but it will go faster. If my lord will keep it any day next week, my lord, then together with the notes of argument, I could conclude my submissions. Because the basic point taken by them was, it is not a suit under the West Bengal Premises Tenancy Act. It should come under the Transfer of Property Act, because they use the word admittedly. Admittedly, the rent was 11,000 rupees per month, which is more than 10,000. We say no, that is not the case. The initial rent which was fixed was 5,000 and odd, which included municipal rates and taxes. The arrangement between the parties was that if there was any increase in the municipal rates and taxes, that would be paid for by us. Sometime in the year 1997, to be very precise, my lord, the rates were.
There is a disputed question of fact.
There is a lot of disputed questions of fact, and in law also, my lord, it cannot be said that it comes under the Transfer of Property Act, because Section 45.
Question of disputed questions of fact and law.
Yes, and law. Because my lord will have to look into the provisions of Section 45 of the 97 Act, which says that if a suit was pending as on the date of its promulgation of the new Act, my lord, they will be governed by the old Act. My lord, all those sections I will just have to cite before your lordship, but I was just submitting. My lord, the notes would perhaps assist your lordship further. Kindly keep it any day next week, my lord. I shall not take more than 15
In fact,
minutes.
according to you, there are scopes of argument.
Scopes of argument and
In suit.
In suit and necessity of evidence. Because whether, my lord, the rent consists of just monthly rent or whether it excludes municipal rates and taxes.
Now, let me know what is GA4?
GA4 is my application.
This is 4.
This
Summary
is 4.
judgment.
Yes. GA3 is judgment on admission. GA4 was
applications
similar, but it's there for
So when I have part heard it, let it be disposed of first.
Yes.
Let 4 be disposed of first.
Then GA5.
G5 is perhaps my learned senior friend's application.
That both the suits, I also have a prior suit ban between the same parties where I've also.
So we'll come to that later on. So we are hearing GA4. Yes. GA4 is hardly in part adjourned to.
My lord, only one submission. My lord, I would never stand in the way of my learned senior friend. Since January, my lord, this hearing is
Next week. I will fix it next week.
Next week.
30th April.
My lord, if they can serve a copy of the notes also.
Item 9. What is item 9?
Item 9 is my learned senior friends. No, that is
No,
the
that's
other
not-
suit. That's a different suit, my lord. It's a prior suit filed by my
The
learned.
prior suit for one of the reliefs is the same. I've claimed a declaration that I'm.
This is CS Com 690.
690 of 2024, old CS number 189 of 2011. This is my suit as the landlord seeking eviction of a tenant. The item 9 in my lord's list is the suit by the defendant tenant seeking declaration of his rights in respect of the property.
So there will be a problem. Once I dispose of all these applications, these are part heard matter. The suit will not remain with me.
Doesn't matter. The order 13A can be disposed of by your lordship.
Yes.
But the second suit has been specially assigned before your lordship. My suit. It's been specially assigned before your lordship. My lord, we will come to that problem later on, my lord. Let us just deal with GA4 first, since it's part heard. Thereafter, we will see how best to come out of the situation.
All right. Then 9 also.
My lord will kindly not tag the two suits. Let them
Yes,
be adjusted.
I cannot tag these two
Yes.
suits.
Yes.
Let it be in the list because
Yes.
that's specially
9
assigned.
করে দিন আলাদা order করে 9 the suit will appear in the list on 30th April.
My lord, if an advance copy of my learned senior friend's note can also be provided so that we can finish.
Before your
Yes,
lordship, then if necessary, I'll definitely hand it over to my lord. My lord is keeping it next week on
30th April.
30th April. Very good.
Obliged.
Very great.
Let this be finished. This list be finished. So eager for appellate side matter. I won't take it up then.
Item number 5.
Let me finish original side matters. Other matters are there. It's not your case only. The matter form.
Content matters. It's a content matter. So
Let the original side matters be.
content matter. So I am the content matter. So I will be present actually up to 2 or 3 years. If you are just kind enough to fix the matter at any time. Item 1 we both are present.
Let me see how much can I do the original side list.
Item number 5 and 6.
Your Lordship, I'm appearing on behalf of the plaintiff in suit CS 204 of 17 and in defendants in the suit 256 of 18.
I'm for the defendant in suit 204 of 2017 and plaintiff in 256 of 18.
Your Lordship disposed of it on 31st January 25, Your Lordship, based on settlement.
Order ta kothay? Both the suits should be disposed of.
Your Lordship, that's for the correction, I believe. Last line, let the suits be disposed of.
Both our application for drawing of the decree has been
Your Lordship, in the order, just one suit is mentioned. Singular.
Number was single. In the terms of settlement, you have only mentioned CS 204 of 17.
Your Lordship, we have filed in both the suits the
the
settlement.
terms of settlement was filed in only suit number 204, but the
Yes.
terms of settlement talks about
Where
256 as well.
it is said?
Your Lordship, in G810, we have filed.
Not G10. Come to the terms of settlement.
তো দুটো কথা বলেন, দুটো সুটের কথা বলেন।
All throughout only CS 204 is mentioned.
Both the suits were disposed of, Your Lordship, because they were tagged together.
We are going with the terms of settlement.
Your Lordship.
What the parties have settled, we cannot go beyond that. Now, where have you said that this 204, except 204, the other suit will be disposed of, or all these suits shall be disposed of? Show me.
Your Lordship, inadvertently, I'm not carrying the paper at present, since kindly keeps it in to be mentioned tomorrow, Your Lordship.
This court, in terms of order dated 31st January 2025, ordered that the suit be decreed on compromise in terms of settlement contained in the supplementary affidavit. Inadvertently, the term suits within court was not mentioned. Full stop. Two suits are pending, namely CS 204 of 2017 and CS 256 of 2018. Clause 12 of the terms of settlement makes it clear that all the cases filed by the parties should be withdrawn. Full stop. Therefore, in terms of settlement, both the suits, namely CS 204 of 2017 as well as CS 256 of 2018, shall be withdrawn. To that extent, the order dated 31st January 2025 stand modified. Decree may be drawn up in respect of both the suits.
I'm so grateful, Your Lordship. So grateful.
Yes. Item number 7.
My lord, I appear for the petitioner in the probate proceeding, my lord. My lord,
For the defendants.
in this matter, my lord, witness action was ongoing. Examination chief of the attesting witness was over. The cross-examination was to commence, my lord. My lord, will kindly fix a date when the examination
Witness is
can
not
go on.
there.
Today it is to be mentioned. It was only for, my lord, fixing a date. If
The
it
suit will
commences,
appear in the list for witness action. What about these pending GS?
there's several pending GS, my lord, but then my lord, the parties intend to proceed with the main suit itself. Then all the GS, my lord. There's GS also for appointment of administrators pending till it
GAs are
is several.
basically for injunction
Yes.
and appointment of an administrator.
Let the suit be
pending
disposed of.
Yes.
But
Yes.
the suit, we are proceeding with the suit, so the GAs cannot may be kept at abeyance for the time.
At the time of final disposal, the suit will be disposed of along with pending application.
Yes. Yes.
Date bolo?
My lord, could it be between my witness, my lord? It would be convenient if it's between 5th and 7th, my lord. If it commences to, my lord. If my lord's
6th?
Yes, my lord.
My lord,
Suit? Yes.
But I have very humble request, my lord. We have made an application so that we get a colored certified copy of the will. Because what we have been served, my lord, is a copy of the probate application. And we have taken the point of the signature being forged.
Sorry.
We have made an application.
Where is that application?
That is application, my lord, in the department that we have to make, like for getting certified copy.
Let the matter come before me.
But my lord, we have been told by the department that unless and until an observation is
So you have to file application then. Let the note become.
Yes.
Very well. Because this
The
document.
suit will appear in the list for witness action on 6th May.
Obliged.
Item 8.
Item 8, my lord, on the last occasion, your lordship observed that the matter shall appear on 20th May of 2025, but it is inadvertently, it was mentioned that 28th May, that is the holiday, my lord.
The suit will appear in the list on
The matter,
20/5/2025.
Item 10.
My application for amendment of plaint.
Who is the other side?
My advocate on record is also not with me right now. Although the amendment I'm seeking is because of documents which have been disclosed by the defendant, number 1. Other side, Mr. Dheeraj Trivedi appears normally in this matter. Your Lordship.
So many defendants are there.
Yes, my lord, but only defendant number 1 is contesting it seriously.
Ratnakar Commercial.
Ratnakar Commercial. Here, my lord, what has happened is, my lord, defendant number 6 owns a very valuable property. Defendant number 1 is the plaintiff is a shareholder of defendant number 6. The property of the defendant number 6 has been sold at an undervalue and under fraudulent circumstances. So for that, I have come before court challenging the sale of the property of defendant number 6. Defendant number 1 is presently the owner of the
Now,
property.
what are the proposed amendments?
The proposed amendment. What is the proposed amendment annex, my lord? The amended in marked with X. My copy, the proposed amendment is not there. My advocate on record is not with me. I know what the amendments are. My lord, if your lordship takes page 22, my lord, page 20, in fact, page 20, a supplementary affidavit had been filed by the defendant number 1 in an appellate
Page
proceeding.
20.
Page 20. A
Supplementary
supplementary
affidavit.
affidavit was filed by this is the defendant number 1. They had filed it in the appeal proceedings. Page 22, paragraph 6. They have disclosed particulars of a sale of the property. Property in Kolkata, my lord, the sale deed has been registered in Delhi. Your lordship will find.
So you came to know about this from this affidavit.
Only in this affidavit. So I have.
Why this ground is furnished?
My lord,
What have you stated this ground?
my lord, paragraph right at the beginning, my lord. Your lordship takes, my lord, para 10 and 11. 10 and 11. Hi. Paragraph 10 and 11. Hmm? And the particulars of fraud on which I am challenging, which I am adding now, is in paragraph 15.
What are the proposed amendments?
My lord, it is a copy of the plaint annex, my lord, the proposed plaint with amendments. My lord, in High Court, how we do, my lord, is, my lord, the entire plaint is marked as annexure X. My lord, my copy, unfortunately, although, my lord, if your lordship, at paragraph 21 of the petition, the proposed amendments indicated in red ink on a copy of the plaint is annexed here too. But unfortunately, my copy doesn't have it. I don't know. And my advocate on record is not with me. That's why I'm a little bit handicapped, my lord. Your lordship will keep it tomorrow in that case, my lord. Plaint copy annexure X second volume second volume full. My lord, if your lordship sees page 100, I think it's the second volume of this application.
There must be second volume.
Second volume, page 100. That's the annexure X, my lord, page 100. Your lordship will, my lord, take paragraph 40A at page 127.
A is the new new.
These are the
addition.
proposed amendments. These are the
48
proposed
is
amendments.
running from 40A to
48 to 40
E.
G at page 136.
40G.
40G.
Mr. Mukherjee, the learned counsel for the plaintiff is present. None appears for the defendant. Defendants. Last order. What is the last order sheet? Adjourn to first May for hearing.
Oblige, my lord.
For hearing GA 9 of 25.
and 12. Lordship, on the last occasion, these matters your lordship was pleased to release GA6 along with the main suit for lack of determination, your lordship. GA7 and GA8 were parted. Your lordship, we have made an application for assignment of the suit and GA6 before this bench. Your lordship, the assignment is still pending. I'm praying for a fortnight's time. After the assignment is done, your lordship make here GA6, 7 and 8 together.
Adjourn to so far as suit is concerned, I have no determination, so I cannot pass that order. Yes. Adjourn to 20th May.
Lordship, the interim relief may be extended.
Interim relief may be extended till date.
Obliged. Item 13 and 14.
My lord, 13 and 14, my lord would recall that matter where the Marseille Court's jurisdiction was, my lord was considering that
Yes.
demerer application. My lord, that is my demerer application and the plaintiff's application for transfer.
No, first thing is whether this is a commercial suit or
My
not.
lord, that is what had fallen from my lord on the earlier occasion. My lord, the plaintiffs had filed that application and that application is pending. So
that application, I am sending it to commercial division. Because I cannot pass the order demerer application without having jurisdiction. Once the suit is decided to be a commercial matter, it's very clearly a commercial matter.
My lord, may I just indicate, my lord, on the earlier occasion it had fallen from my lord, I was to address my lord. My lord, I do not wish to linger this any further. My lord, I just had one prayer subject to my lord's pleasure. My lord, if my lord is transferring it to the commercial, if my lord makes an observation that this is without prejudice to the issue of maintainability which I have raised.
I will pass no such order because I am just transferring it.
My lord, if the issue of maintainability just kept open, because
all right,
I just that point, my lord, nothing more than that.
The suit appears to be GF4.
My lord, GF4 is their application for transfer.
GF4 is filed, praying for transfer of the suit to commercial division. Full stop. When the suit was filed?
My lord, the suit was filed in 2015, my lord. And the application in 2023.
No, suit was a pending suit at that time.
My lord.
The prima facie reading of the plaint shows that the dispute is related to sale of goods.
My lord, it is not sale of goods, my lord. My lord, it is, my lord, according to their
commercial nature, not sale of goods, it's a commercial nature. Let the suit be transferred to the commercial division. This arekta kotha likhe din, the suit was filed when the act came.
My lord, 2015. My lord, the notification came later, my lord.
Later on.
My lord, later on.
At the time of the suit was filed prior to coming into effect of the Commercial Courts Act 2015. Let the suit be transferred to commercial division along with all pending applications. It is made clear that this court refrains from making any comment on maintainability of the suit.
My lord, may I just make one prayer, my lord? My lord, if the issue of maintainability can be kept open, that's all, my lord.
All the applications including application for maintainability shall be heard by the bench having determination. This much.
Grateful, my lord. Grateful.